Breaking news, the New York Times and the Washington Post have both published today articles about how YouTube, believe it or not, is trying to encourage conservatives and election denial information and the like. This is obviously some sort of a coordinated attack on conservative commentators. And let's talk about how this plays a role in the Second Amendment, and in particular in something known as tiers of scrutiny, which we sometimes have to remind you why that notion is so dangerous to our right to keep and bear arms, and actually to our right to free speech. We'll break it all down and make you the smartest person in the room when we come right back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of Israel Disarmed: What the 10/7 Attacks on Israel Teach We Americans About the Right to Bear Arms. Check it out if you have a moment. All right, folks, so we're going to get a little geeky here today. We're going to tie it into something just occurred, and we're going to break it in and weave it in to some issues in courts that I want to remind you about, something that's particularly very dangerous to our right to keep and bear arms, and also to our right to free speech. So specifically, today, you probably have seen this in other media. The New York Times and the Washington Post have now published articles, really by their technology reporters, discussing how social media companies, in particular like YouTube, owned by Google, are somehow profiting off alleged election interference or alleged election denialism or alleged, things like that. And of course, they've identified only, as best I could tell, conservative or right-leaning political and other commentators. Obviously, reading between the lines, in my opinion, this is really a message to YouTube that says, take these people off the platform, demonetize them, turn them off, shut them down, don't promote them, whatever. That's obviously what this dual message is. I suppose the other related message may be that if Donald Trump wins the election over Kamala Harris, perhaps this is a setup so that these newspapers and other members of the left-wing legacy media that's dying bit by bit can go back and say that the reason why Kamala Harris, who was the best candidate ever, lost to Donald Trump, the worst candidate ever, was because of this social media not cracking down on misinformation or disinformation. Now, it is this jumping off point that I want to remind you something very important, and you're going to learn something here today that I don't think you're going to hear anywhere else. It's a very nuanced legal point, but you got to understand this. Very important. Most lawyers and judges will not understand what I'm about to tell you, but you will. Okay, and that's this. We have to be very careful with this public commentary by legacy newspapers and legacy media, which is really, as best I can tell, is sort of an extension of the arm of the federal government deep state that wants only one narrative or one viewpoint to be expressed. And I can assure you it's not the viewpoints expressed on this channel. That's my guess. The key is to understand something else about demographic change as it ties into this. And what do I mean by that? If you look at surveys and talk to baby boomers, I'm not a baby boomer, but I know lots of baby boomers, and even my generation, Gen X, you'll see a sympathetic view toward public speeches, debate, civil discourse, writing letters, fighting it out in the marketplace of ideas, reading all sorts of books and information, and not engaging in censorship, no matter what. Gen X and the baby boom generation, by and large, are of the view that if you confront bad speech, inaccurate speech, misinformation, or disinformation, then the proper way to deal with that is not by censoring it, but is instead by combating it with better, more accurate, correct information, more persuasive information in the marketplace of ideas. No different than the scientific method, where you all engage in a series of tests to try to figure out the right scientific answer, and you're constantly learning and fine-tuning scientific knowledge in all fields. Now, the reason why I understand that the Gen X and baby boom generation are generally pro-free speech and freedom of ideas to allow bad information to get out there and be confronted with good information. Bad speech gets confronted with good speech, let's say, or more speech. That is a dramatic difference from the younger generations, and this is particularly important for our rights. Why? Because what I'm about to tell you in terms of the younger generations and their views on free speech and their views on the role of government in life will have an impact going forward as those younger generations move from being students and young attorneys and young professionals. And they get elevated eventually onto the bench, either as state judges or federal judges, and eventually Supreme Court justices. And why is this generational disconnect important? And why is it that, and I'll put some articles down below so you can see what I'm talking about, why is it that young liberals who used to be very supportive of free speech are now like the least supportive of free speech and are all about censorship, shutting down what they label misinformation or disinformation, and making sure there's only really one viewpoint, their viewpoint, and all conservatives, right-leaning viewpoints are censored, shut down, or demonetized or gotten rid of in some way. So once you understand this generational divide, I now want to bring this to not just the free speech issue, but also to the right to keep and bear arms. And how so? If you may recall, before the 2022 Supreme Court decision in NYT versus Bruen, the lower inferior courts were all engaged in what's known as interest balancing, sometimes referred to as a process applying the tiers of scrutiny, which basically is an insane approach to interpreting the Constitution. Even though this is still used today in the context of the First Amendment right to free speech, we have that body of law mostly because it's built up for decades and decades and decades, and it's not that easy to get rid of barnacles on the American legal system that everyone's been using for decades. There's a reliance concern. People have relied on that body of law for so long and learned it and used it and organized their life and society around it that the court is often hesitant in such a situation to willy-nilly get rid of it, even though they think it may be wrong. So the reason why this is important to understand is the way the tiers of scrutiny, and you're going to be shocked with what I'm about to say because it's still used. The way the tiers of scrutiny is used is really a form of interest balancing where you hand a public policy question to judges. Now, up till now, for the last 4 or 5 decades, the people on the federal bench, the judges in American life, have been mostly basically part of the baby boom generation and to some degree the Gen X generation. And thus they were sympathetic to the idea if you get to read a lot of books, you get more information, you get to debate, you get to give speeches, we have a fight, right? And so on and so on. As a consequence of that sort of value system of that older generation of judges that are still with us right now, because of that value system that was favorable to free speech, what happened was when the tiers of scrutiny system was set up and deployed for the last 4 to 5 decades, the impression among many, including many people on the right, including some scholars that are otherwise conceptually pro-Second Amendment, pro-guns, they think that the best way to protect our individual rights, including the right to free speech and the right to keep and bear arms, is to bring back some form of tiers of scrutiny, which again, tiers of scrutiny is a euphemism for a form of government interest balancing. It's an interest balancing test, which weighs on the one hand the importance of your right to free speech versus the compelling or importance of the government's interest in censoring or stopping that speech. That's how it works. Now, what's crazy about the fact that there's some pro-Second Amendment people out there thinking that this tiers of scrutiny or intermediate scrutiny is valuable to not just the right to free speech, but the right to the Second Amendment, and this is where I'm going to tie into the generational conflict, is because they point to the last 50 years of many favorable rulings in favor of the right to free speech over government censorship interests. So you'll have this discussion with pro-Second Amendment people, and they'll be like, look, tiers of scrutiny's worked out really well In the First Amendment context, look at all these cases, the Pentagon Papers, Sullivan, New York Times versus Sullivan, right? All these kinds of these cases where there's discussions that say, look, the free speech, the right to read the book you want to read, the right to give the speech you want to read, the right for Nazis to march down the street in Skokie, Illinois, in a predominantly Jewish community, and so on and so on. Look at all these examples where free speech trumped the government censorship apparatus. It trumped the argument that there was a compelling state interest or compelling government interest to censor the speech. Therefore, and this is where they go wrong, therefore, it shows that tiers of scrutiny and interest balancing is really good for rights. It's really good for individual freedoms because it's worked so well. Listen carefully. It's worked so well in the First Amendment context dealing with free speech. But this is where the generational divide destroys this notion. And then I'm going to show you how absurd it really is in a moment. The reason why the tiers of scrutiny has worked relatively well so far as an interest balancing, weighing mechanism of these federal judges weighing really ruling in favor of free speech over government censorship efforts is because the judges who are overseeing and have been ruling on these cases for the last 4 to 5 decades are of those generations that are pro-free speech, that are anti-censorship, and are all about debate and civil discourse and defeating bad speech with good speech or more speech. That's fine. But what's coming behind those judges, what's coming behind those generations is an entirely different group of Americans. It is a group of Americans that we saw that want to censor, shut down so-called misinformation and disinformation, and the Biden administration wanted to do this about COVID and other issues. And if you look at the survey after survey, the younger generations are far more inclined, as the article I'll put a link to down below, are far more inclined to support censoring opposing viewpoints or viewpoints that they view as offensive. For example, in this one study, it specifically found that recent college students, this is a 2024 article, by the way, recent college students are more likely than their predecessors to say that controversial speakers should not come to campus and that racist or sexist speech should be restricted. While only 1 in 4 students wanted to ban extreme speakers during the 1970s and the 1980s, the majority wanted to do so in 2019. See that generational shift? So as you can see, when the younger generations who do not value free speech and debate, they value censorship and shutting down opposing viewpoints they don't agree with, as they start to become judges, they're no longer going to put their fingers on the scale in favor of free speech over government censorship. It's going to be flipped. And thus, when the pro-Second Amendment people today argue that tiers of scrutiny, interest balancing, is a better approach to the Bruen methodology of text first, burden shifting to the government to show that there's some historical tradition of firearms regulation applicable to the modern gun control law, they argue that is not the best way of doing it. The better way of doing it is the First Amendment context. But again, they're looking at data that it will no longer hold true as new, younger judges start to sit on the bench and start weighing government interest over and above freedom of speech. Now, beyond that, and remember, this is all sort of generated by virtue of this sort of perfect opportunity to talk about free speech and the Second Amendment together with these articles from the New York Times and the Washington Post today targeting conservative viewpoints and conservative commentators. Here is the best evidence, and it's undeniably true in my view, of why the Bruen methodology of text first, history second, if you will, is far superior to tiers of scrutiny and interest balancing. There is no way that interest balancing and tiers of scrutiny can possibly be better than the Bruen methodology. Here's why. I want you to think about this from a common sense point of view. In the First Amendment context, you have the textual right of, Congress shall not abridge, the right to free speech. Okay, that's essentially what it says for our purposes. Okay, it's in the text of the First Amendment is the point. The right to free speech is actually in the text of the First Amendment. It's not made up. And the way the courts have done it, and listen carefully, you'll see the problem. What courts have done is they look at the text of the First Amendment and they interpret the text. Sound familiar? Just like they do in the Second Amendment. Then they look to see, are there historical-based exceptions? Hear what I just said? Historical-based exceptions to the text of the right to free speech. And they say, yeah, there are. For example, they say, fighting words is not protected free speech. That's not speech. Then they say obscenity, not pornography, but obscenity is not free speech, right? Then they talk about defamation, fraud, all these kind of exceptions to free speech. And after they look at the exceptions, you have the start of the First Amendment doctrine. You interpret the text of the First Amendment, right to free speech. Then you look at historical examples of exceptions. There's about 5 or 6 of them, right? And then that is the Bruen test, if you think about it, right? The Bruen test is you look at the text of the Second Amendment and interpret that. Then you look to see if there are historical exceptions, such as the right to you can't commit murder, even if you have the right to keep bear arms. That doesn't give you the right to commit cold-blooded murder. That's a historical exception to the Second Amendment, for example. So as far, what I've just described with the First Amendment and the Second Amendment sound very similar, don't they? And here's where the argument in favor of tiers of scrutiny goes off the rails. In the First Amendment context, because of the last 50 years of jurisprudence by liberal judicial activists, even if you find yourself in a situation where your right to free speech is being abridged or infringed upon, violated by the government, and your free speech you're using is not fall within any of those historical exceptions to speech, like obscenity or fighting words, the government still has another opportunity to win. So even if, in the First Amendment context, the government loses at the first level, at the textual level and the historical level, the government has another opportunity to win. They get another bite at the apple to censor you as an American citizen, notwithstanding the fact that the censorship undeniably violates the text of the First Amendment and doesn't fall within the historical exception of the First Amendment. They are given another chance if the government can show that there is a compelling state interest or some other, depends on the standard here, could be compelling state interest, could be whatever it is. The point is, that regardless of the standard, there's another way for the government to win, another bite at the apple if they can show that it's a really important governmental interest in some way that overrides the interest of you speaking. You see what I'm saying? So those Second Amendment people that are interested in bringing tiers of scrutiny and interest balancing into the realm of the Second Amendment are, in my view, totally wrong. Because what you're really saying to argue that is once the Second Amendment advocate shows that a modern-day gun control law violates the text of the Second Amendment, and then you look to see if there's a historical exception by looking at the historical tradition of firearms regulation, and then there is none, the tiers of scrutiny supporters would then say, now, even though the government has lost the Bruen methodology of text first, historical regulation second, we're now going to give the government another chance to show there's a compelling state interest or some important state interest to justify the modern-day gun control law. You're giving the anti-gunners and their handmaidens in the government another opportunity to win a Second Amendment case to take away our rights. Because remember, tiers of scrutiny says, even though you have a right to free speech or even though you have a right to keep and bear arms, if the government has such an important interest to justify infringing on your right to free speech, or if you did it in the Second Amendment context to infringe on your right to keep and bear arms, then the government wins and you lose your freedoms. This is absurd. It only exists in the context of the First Amendment because of 50 years of precedent, and the only reason why it appears to have worked in favor of freedom for the last 50 years is simply because the judges applying the tiers of scrutiny interest balancing test happen to like books, happen to like speeches, happen to like debate, happen to like civil discourse, happen to like the viewpoint of you defeat bad speech with more speech or better speech. But once those generation of judges flips over and the younger generation that believes in censorship over free speech and conformity over controversy, the First Amendment freedoms will be dramatically shrunk, in my opinion. And that's why we absolutely do not want to bring these tiers of scrutiny or interest balancing tests over to the Second Amendment context for the reasons that we've just discussed in this video. All right, folks, so there you have it. Hope you had a good Halloween. Make sure you follow me on X at 4boxes Diner. Don't forget to like this video and share it, and we look forward to talking to you again here very, very soon at 4boxes Diner.
Orders up. Table 2A.